All right, CBS News has obtained a memo that shows that ICE agents can force their way into a suspect's home without a search warrant from a judge. Vice President J.D. Vance defended that memo today.
What the Department of Homeland Security really has proposed in the Department of Justice is that we can get administrative warrants to enforce administrative immigration law. Now, it's possible, I guess, that the courts will say no, and of course, if the courts say no, we would follow that law. But nobody is talking about doing immigration enforcement without a warrant. We're talking about different types of warrants that exist in our system. Typically, what happens, not always, but typically in the immigration system, those are handled by administrative law judges. So we're talking about getting warrants from those administrative law judges. And then, of course, with other cases, you get judges or you get warrants from a judge. That's very consistent with the practice of American law.
Let's bring in CBS News legal contributor Jessica Levinson to walk us through the difference between an administrative warrant and a search warrant.
So we should actually, I think, say administrative warrant versus a judicial warrant. And that's really the sea change here, where the internal memo indicates that the guidance will change and that a judicial warrant, which previously was the only thing that would give immigration officers or anybody else the power to forcibly enter somebody's home, that will now be expanded to include administrative warrants as well. Administrative warrants are essentially issued internally from a federal agency. So what's the difference? When we're talking about judicial warrants, the difference is important because we're talking about a member of a different branch, the judicial branch acting as a neutral check to make sure that there is, in fact, probable cause to take that step of saying, we will enter somebody's home by force when they don't give consent, even if there aren't emergency circumstances. That brings up serious Fourth Amendment considerations. That's why the Supreme Court has, I think, for a very long period of time, consistently said you need a judicial warrant to forcibly enter somebody's home.
So Vice President Vance mentioned the courts could say no to administrative warrants being enough to enter a suspect's home. So what is the current legal precedent?
So I think the current legal precedent, not just with respect to the guidance from the Department of Homeland Security that's been given to ICE agents except for this memo, but also the current state of the law from the Supreme Court, from Fourth Amendment jurisprudence, which protects all of us against unreasonable searches and seizures, indicates that you do need that neutral check. You do need that judicial warrant before you forcibly enter somebody's home. That would, in my view, change that guidance. And that's why I think Vice President Vance is essentially telegraphing that they know that there will be legal challenges here.
Jessica Levinson. Jessica, thank you.